this week. We're all here. Yes, Mr. Ewart.
Good afternoon. We're going to look at British and Bennington's.
Yes.
Which is behind tab 8.
Tab 8. I gather that Lord Justice Newey was having a bit of trouble hearing us. Not you, but us. So I think we'll have to keep our voices up.
I'm sorry. So the facts in this case...
I might explain that actually for some of the morning I swapped to listening on the live streaming, which is much easier to understand, or was easier to understand, but the snag with that is that it has a time lag on it. Anyway, I'll hope that the volume works better with CBP this afternoon.
Good. I think that's in case we say something unfortunate, so you can stop the thing. I'll try not to. The facts of British and Bennington. There were 3 contracts entered into between the appellant and 3 respondents, under which the respondent sold tea to the appellant to be delivered to a bonded warehouse in London. There were 7 other provisions in the contracts apart from that as to delivery, and that becomes significant later. There was unfortunately great congestion in the Port of London in the early part of 1920, and by order of the ship controller apparently, the ships were ordered to other ports, in this case Greenwich, Plymouth and Leith. Unfortunately, these ports were also greatly congested, and so the weighing of the teas was greatly delayed. A parole agreement was held to have been made on the 12th of May 1920 to the effect that the buyer, the appellant, would take delivery of the tea at Greenwich, Leith and Glasgow instead of London. The buyer, the appellant, repudiated the contracts on the 15th and 18th of July. It was held that the parole agreement did not rescind the written contract because it only varied 1 term as to delivery. That was not enough to evince an intention to rescind. It also only related to part of an overall contract, a larger contract. The case was then decided on a point of repudiation, and the respondents were ready and willing to perform. That was what was held. It was held that after the wrongful repudiation by the appellants, the respondents were not required to prove that they were ready and willing on that day to deliver teas at London. It didn't require direct transportation to London, so they could still perform, or they could still say they were ready and willing to perform. So that was how the case was decided. However, as part of that, as you can see, the question of rescission came up, and Lord Atkinson dealt with that, in particular on page 128. Where he says, you see in the middle of the page, a written contract may be rescinded by parole either expressly or by the parties entering into a parole contract entirely inconsistent with the written one, or if not entirely inconsistent with it to an extent that goes to the very root of it. And for that he cites Morris and Barron and other cases. So I wonder, my Lord, whether the key thing is inconsistency. And it's a question of the extent of the inconsistency. It can be either entirely inconsistent or inconsistent to the extent it goes to the root of the contract. So that's the way Lord Atkinson put it. And he decided that, as I indicated earlier, that changing a single provision such as this did not result in a rescission of the contract. And then he went on to deal with the questions about being prepared to deliver or ready and willing to deliver. And then Lord Sumner, who gave the other speech, the others all concurred either in person or in proxy. He dealt with this at page 134.
Don't you also want 133 at the top at Little Roman 2?
Yes.
Question is whether the common intention of the parties was to abrogate, rescind, supersede or extinguish the old contracts.
Yeah. By a substitution of a completely new and self-contained or self-subsisting agreement, yes. containing as an entirely the old terms, together with and as modified by the new terms incorporated. So again, that envisages a situation where the new contract might still have terms from the old contract in it by reference. And he, so as I say, he deals with it in paragraph 134, the paragraph that begins under these circumstances. It's plain that the 3 original contracts were not made an end of in May 12, 1920, but were meant at most to be subjected to a variation or alterations to the manner and measure of performance. The changes not go to the very root of the original contracts, nor is it inconsistent with them. It merely varied the written contract by parole. The situation of the parties has been otherwise unchanged. I therefore think the agreement has no effect on the original contracts, not having been reduced to writing and signed by the buyers, not having superseded the original contract. And then he discusses briefly what he calls the logical position, which is the position that any variation results in a new contract, which I think was a point of argument at that time. Perhaps some people took the view that this was the logical position, but anyway, he says that's not the way it was approached in Morris and Barron. It may be strictly logical, but it's not the law. And he says at the end of that, you'll see on page 135, the old contract, the discharge of the old contract must depend on intention, tested in the manner settled in Morris and Barron. Now, there's nothing in any of these either of these cases, indeed any of the cases, that suggests that this has anything to do with the subjective intention of the parties. This is the really strange thing about this case. All of the authorities speak with one voice. And I think it's tolerably clear that that was the view of Lord Justice Toulson in Samuel and Wardlaw, which is in, I'm afraid it's in Authorities Bundle B, tab 26. Now, the claimant, who was a recording artist, Seal, entered into 2 relevant agreements. One was a management agreement on the 1st of September 1990, and one was a settlement agreement when the disputes arose as to the management agreement and other agreements. The question in this case was whether Seal could set aside the settlement agreement on the grounds of undue influence. And the position seems to be that there was a very good case for undue influence in relation to the original management agreement, but the position at the time of the settlement agreement was quite different. Because at that stage, he had legal advice. The manager who he's entering into the agreement with was not in a fiduciary relationship with him, I think it was held. So I think it was common ground, it seems to be the position in the Court of Appeal, that if it was you're only looking at the settlement agreement, then you couldn't set it aside for undue influence on its own. However, it was argued that they said that the settlement agreement had rescinded the management agreement, and the result of that was you could look at the circumstances of the management agreement in determining whether there was undue influence. It's very puzzling. I think the answer to it is, if you look at paragraph 53 Now, this comes after a passage in where Lord Justice Toulson has been looking at cases such as Royal Bank of Scotland at Ettridge, Yorkshire Bank and Tinsley, which are about cases where there is a charge or mortgage entered into with undue influence, and then there's a substitute charge entered into in reorganising the charge. And it was held by Lord Justice Longmore, and amongst others, that where there was a substituted contract, you could look at the undue influence in the original contract. That was because once you entered into the original charge, you were kind of forced to take the substitute charge because you're already in the first charge. So there was no. It was really a continuation of the original undue influence. That was at least what the courts decided. In this case, the claimants were trying to apply that to this situation. And if you look at what they say in paragraph 53, it was suggested in argument that Lord Justice Longmore was there seeking to lay down a principle of law that a contract which was a true substitute of an earlier contract, voidable for undue influence, will be automatically unenforceable, subject to late issues or the like. That suggestion led to rather unsatisfactory attempts to formulate definitive tests of what would amount to a true substitute. That trail leads quickly back to the sort of problems we already looked at when considering whether the second agreement involved a discharge or variation. So I think what was being argued, what I can understand it is, if it did rescind the first contract, then it was a substitute for it, and therefore you could apply this supposed principle. Now, Lord Justice Toulson said that was wrong, that was misconceived. You had to look at the second contract, which was a completely separate contract in separate circumstances, and decide whether there was undue influence.
Well, it also misses out the second half of Lord Justice Longmore's rationale in paragraph 52, bottom of page 494, where he talks about the factual situations had to be materially similar, and it's a condition of the rescission or release of the original void or voidable bargain that you enter into a new one. So you've got the causal link plus the material conditions being the same. Then you can read the one across to the undue influence into the second. But here, if you've got a separate situation where somebody's legally advised, you don't get undue influence tainting the second transaction.
Yes, exactly. But I was only explaining that to explain why this argument about rescission arose at all in this case, and that was why it did. And so Lord Justice Toulson, he discussed it. Although in the end he concludes he doesn't have to decide that point because, as you say, my lady, it wasn't necessary for this case because undue influence doesn't depend on that kind of thing. But he discusses it between paragraphs 34 and, well, really at the end, 46. And he says that he starts by citing Chitty, saying that it was all very subtle and refined. And then he says the case law is mainly arisen from the statute of frauds and similar provisions. And he refers to United Dominion Corporation, what Lord Devlin said following Morris and Barron. And he then goes on to say after that, paragraph 39. Oh, sorry, just as we're passing that, I think there is a reference in this passage, I'm not sure, to the logical position, because I think one of the issues in one of these cases was, later cases, was whether you should apply the logical position to all variations.
Yes, it's at the end of Lord Devlin's quotation.
Yes.
Choice before the board lies between solving the problem by means of what some would call formal logic.
Yes.
Of solving it by giving effect to the intention of the parties.
Exactly, yeah. So they chose the latter course. And then goes on to say, however, it may not be easy to determine whether the parties intended, notice he puts that in inverted commas, that the original contract should continue to exist as a matter of legal analysis, but in varied form. So he's clearly not looking at intention in the kind of sense of what people's actual intention is, but what the intention is as a matter of legal analysis. Or whether as a matter of legal analysis it was intended to be discharged and replaced, since the distinction is one of legal theory, which might have no commercial meaning for the parties. In the present case, it's plain that what the parties intended to be the effect of the settlement agreement in terms of their ongoing financial rights and obligations, but to ascribe to them an intention to achieve that result by variation of the management agreement, as distinct from its replacement by the settlement agreement or vice versa, is artificial. From a practical viewpoint, it's a distinction without a difference. In Morris and Barron, the House of Lords used a variety of expressions to formulate a test. In British and Bennington's, Lord Sumner collected the various phrases used and said that the question was whether the common intention of the parties was to abrogate, rescind, supersede, extinguish the old contract by a substitution of a completely new self-contained or self-subsisting agreement containing as an entirety the old terms together with as modified by the new terms. In this case, the settlement agreement was plainly intended in a broad sense to supersede the management agreement and the publishing agreement, but whether it was intended to extinguish the prior agreements is more debatable. The settlement agreement dealt comprehensively with the parties' continuing obligations, but it did so in language which imports parts of the management agreement. Mr. George submitted rightly that the management agreement could be terminated without being discharged. If the management agreement had been terminated in accordance with the notice provisions, the post-termination provisions would continue to have legal force, because the contract would continue to have validity, while the term of the management contract would have expired. Similarly, he submitted the termination of the agreement or the settlement agreement did not extinguish the contract in entirety. He pointed to expressions in the settlement agreement such as, and he quotes some provisions, and the appellant agrees pursuant to clause 5 of the management agreement he uses reasonable endeavours, as showing that the management agreement was not being entirely extinguished. So again, a normal, completely orthodox way, the case is being argued on the basis of the agreements, the terms of the agreements. The respondent argued that the continuing obligations took their force only from the terms of the settlement agreement, and that the reference, for example, to him being entitled to his commission, as defined, was merely a convenient way to identify his rights. It's a fine question. I consider it also a sterile question. The law about undue influence is based on broader concepts, and I do not believe that its application to the present case should be affected by whether technically the settlement agreement discharged the management agreement. And he says that the principle in Morris and Barron was brought into existence in order to deal with the technical problems produced by legislation analogous to the statute of frauds. The less that is brought into other parts of the law, the better.
I'm sure I entirely follow that paragraph. What is the principle in Morris and Barron that he's referring to?
I think it's
That you can
the
have
distinction
between a valid but unenforceable parole agreement. Is that the principle? Or
no, I don't think it's that.
You're applying a test to decide whether there has been a variation or rescission?
I think it's that, yes. Yeah. He seems to see that as having been developed.
But then he says that's a formalistic approach, whereas Lord Devlin thought it wasn't a formalistic approach. He thought that the formal logic...
Yes, well, the formal...
You shouldn't solve the problem by formal logic, but you should do what was done in Morris and Barron. So why does Lord Justice Toulson think that was formalistic?
Well, he may be simply thinking that the line of thinking may be it doesn't matter in these contexts. It doesn't matter in this context.
No.
It only matters in statute of fraud type contexts. I mean, he didn't have tax in mind, obviously, but
he was grappling with an equitable principle of undue influence, which shouldn't. I think what he's saying is it shouldn't depend on whether the second agreement replaces the first agreement. What you've got to look at is to see whether the influence continues to extend to the second agreement, or whether the second agreement is entered into willingly. And for the purposes of that inquiry, it's absolutely irrelevant as to whether or not it supersedes the first agreement. That, I think, is what he's driving at.
Formalistic may not have been...
I'm not sure that this case greatly helps us, though, one way or the other, on what the principle in Morris and Barron is.
Well, I think what it helps you in that, certainly from this case, you get that this is a matter of legal analysis.
Yes.
And it's a matter that you decide by looking at the terms. Well, that's important for this case because, of course, the starting point in this case is the Upper Tribunal says you don't do that. Where the parties have actually got an intention that you can identify, you look at that. So this case is completely inconsistent with that, I would suggest. But I agree, it doesn't tell you precisely what the test is, except that he cites Lord Sumner, who's...
Yes.
But and it's obviously obiter because he says it's not relevant,
Yeah.
and he goes on to decide on a completely different ground.
Yes.
Can I just raise a query?
Yeah, so,
You've made the point a number of times that it's not about subjective intention, and I follow that. Suppose you have a document which states in itself, in clear terms, that it is to take effect by way of variation rather than by way of rescission. So it's not a matter of what the parties subjectively think, it's there in the document. That's surely an objective manifestation of intention. Does that prevail?
but that's a manifestation of their subjective intention. The subjective intention is that it should not be a variation. But if whether it is a variation or not is a matter of legal analysis, then that can't prevail. Just as in the cases of
You can call it a license, but if it's a lease,
Street in Mountford
if it's a tenancy, it's a tenancy.
Agnew, etc. The cases it's a case of analysis as to whether there is a new contract or there is a original
So
contract.
it's not a question of whether they, looking at it objectively, intended the thing to take effect as a variation. It's a matter of whether they intended the thing to achieve a particular result, which necessarily involved a variation or rather a rescission, you say?
Yes, or a new.
It's not really a question of subjective or objective intention. It's a question of, it's a different sort of question.
Yes. Yes, it's their intention as determined in this particular way.
Yeah.
Yeah. Yes, exactly. On the other, it is possible, of course, for the parties to terminate a contract by saying they're doing so, because they're always free to do that. So they could rescind a contract. I think one of the judges makes that point. You could decide to tear up a contract, rescind it, and bring it to an end, and substitute a new contract. The parties could do that because they're free to decide that they're no longer bound by the contract they've entered into. That's the flip
While
side.
I'm asking questions,
Yeah.
can I just take it a stage further and take you out of your course? So suppose I enter into a contract to sell you a chocolate bar, and then a bit later we enter into a written contract stating that by way of variation of the contract to sell a chocolate bar, I will now sell you not a chocolate bar, but a motor car. It's quite plain that the parties have manifested an intention that should be a variation rather than a rescission on the terms of the contract. You say they can't do that because you have to compare what you had before and what you had at the end.
Yeah.
Is there a reason of policy why you shouldn't just let the parties decide?
Well, I think one of the reasons is given. I think from reading my Lord Justice Lewison's book is for the objective test is one of the reasons is if you don't do that, then you open up all sorts of evidential points that people can come along and say, I didn't really mean that, I intended something else, etc. So I think that's one of the reasons.
It's all written down in the contract. You don't have an evidential problem.
Yes, but the policy is to cut out any evidential problem. I think the reason for the approach is to cut that out. It's not a question of only cutting it out where it's a problem. You understand what I mean? It's simply to say you can't give evidence as to what was in your mind in order to decide these questions. But I think the other reason is because it affects third parties, such as in this case.
There may be
but it can affect other people.
There may be different policies in different areas. I mean, for instance, in the Street and Mountford example, the policy is that people who have rights equivalent to a tenancy should have security of tenure. In the Agnew type of example, it's a question of protecting the company's creditors. So there are different policy reasons that sometimes the parties are not free to decide for themselves what the legal consequences are of what they have agreed.
Well, that is true, except in the Street and Mountford case, although it was decided in the context of the rent tax, I understand, it wasn't decided that that's what lease meant just in the rent tax.
No.
It would be the position throughout.
Sure.
Maybe different in Agnew, because that was only a question of what is effectively a statutory concept in the Companies Act, isn't it? Charge for floating or... I can see that's slightly different.
I mean, I quite follow. You get the Street and Mountford type line, and if you call, I can't remember which way round. Is it the three-pronged implement a spade? It's still a fork, or the other way round, or whatever. But in the particular context of whether you are varying or rescinding, it wouldn't normally matter, would it? Why shouldn't the parties be able to choose?
Well, it does matter sometimes, obviously, because there are all these cases where it does matter. I mean, the parties can choose in the sense that if it doesn't matter for any other purpose, they can agree anything they want. I suppose we're getting, I mean, this is a slightly philosophical question in a way. So does it matter where, is there a different contract where it doesn't matter? You might say. I mean, the question only arises when there is some reason for asking it, I suppose. And that might typically involve other parties wanting to know what this position is. Have you got one contract? Have you got another contract? Not just in tax. I mean, I think there are probably other examples where.
Well, you gave the example this morning of transitional provisions. It's quite common to say that this new law won't affect transactions entered into pursuant to a contract made before this law comes into force.
Yes, not just tax provisions, but
not just tax provisions, but all sorts of things.
Yes. And I think that the case which you referred us to, the Australian case, is about telecommunications or something like that, where it can matter whether it was a pre-whatever contract or a post-contract, the rights of third parties. I think that was the context of that.
Yeah.
Yeah.
Thank you.
So that is Samuel Wadlow. And the last case I was going to really look at the moment was Shell UK.
Yeah. Probably go straight to paragraph 121 of that.
Yes, I think we can. Yeah, exactly. Because although it wasn't necessary in the end for the decision because of the way they decided it earlier, they did go on to look at the question of whether there was a rescission or a variation. And they applied exactly the approach which I would urge you to adopt.
121 to 125.
Yeah. So could I just then, on that, just look at, while we've got these cases in mind, just look at what the Upper Tribunal said about them. Paragraphs 96 to 105 first. So, paragraph 96, they reject Mr. Cosman's submission that the differences or inconsistencies in the latter agreement and the existing agreement were so fundamental as to go to the root of the contract. Then this was sufficient to constitute an implied rescission. We don't accept this submission. It seems to us that the case's authority for the proposition of the difference between rescission and variation is dependent on the intention of the parties. In the absence of other evidence, the fact that changes affected by the subsequent agreements go to the root of the existing contract, or that some changes are inconsistent with the contract's original terms, might lead to an inference that the parties intended to rescind, but the question remains one of intention. And then they deal with Wadlow and Samuel.
So just pausing at 96, you say that Mr. Cosman's submission was in fact correct.
Yes.
And that the Upper Tribunal should have accepted it, and that they made an error of law in rejecting it.
Yes, that's correct. And then they deal with Waddle and Samuel, and they quote various passages from Lord Justice Toulson. And then they say, while Lord Justice Toulson pointed out the difficulties inherent in the test laid down in Morris and Barron, we do not consider that he intended to conclude that it was not part of the law of contract, particularly as he already observed in his judgment about it. Well, of course, we agree that he was doing that, but then I think the disagreement is what it actually decided. The case is decided. The upper tribunals think they decided something different from what I would submit they decided. So I think they're in a sense agreeing with us there, but not with the premise. And then Mr. Cosman also referred to Shell.
Yeah.
The special commissioners, and he sets out what the special commissioners decided. And then paragraph 103, Mr. Cosman submitted that the special commissioners had followed the correct approach, at least in relation to what described as a status case, the one at the issue in both Shell and this appeal. We do not accept Mr. Cosman's submission. The decision of the special commissioners in Shell is not binding on us, insofar as they decided that even where both parties share a common intention not to rescind the contract, that contract could nevertheless be rescinded by the parties agreeing fundamental changes to it. We consider this to be an incorrect statement of the common law, given the authorities we referred to. In determining whether the parties intended to change or to rescind the contract, we accept an agreement with HMRC that intention is to be ascertained objectively, which is Lord Clark.
Now, how does that fit with their rejection of Mr. Cosman's?
Well, I was about to say, I would say that these are inconsistent. So that's how they dealt with the authorities, and we would certainly say that the special commissioners in Shell UK were correct, and it was wrong for the Upper Tribunal to say that they were incorrect. They then apply the test rescission.
Now, isn't 108 and 109, are those paragraphs not applying the test that you say they should have applied? Because it starts by saying that Ms. Shaw accepted that the apparent common intention is so inconsistent with the way they acted as to call into question whether it existed at all. And then they go through the various elements and say, well, we don't think that there is sufficient inconsistency. Isn't that applying the test you say they should have applied?
No, because they shouldn't have started from the proposition. They shouldn't have started with the proposition that you look at what their apparent common intention was. Subjectively, and then ask the question whether what they actually did calls into question whether that actually was their intention.
Quite.
That's what's being suggested.
It's putting the cart before the horse.
It's been suggested that, and it's almost a matter of credibility that I think is being suggested that.
Right.
Because if it really does depend on what they intended, then once you've found what they intended, that's the end of it.
I struggle. I'll be honest with this. I absolutely struggle with the last sentence of 106. A common desire to ensure that EZAs will be available to the purchaser of the building ultimately constructed is strong evidence of a common intention that it won't be rescinded. It's got nothing to do with the fact of rescission. I mean, people enter into agreements all the time believing that they may have certain tax consequences. They may be right, they may be wrong, but it doesn't help you to work out what the correct construction of the contract is. Yes.
Well, you're right. Lady, you're absolutely right. And this was obviously a point I was going to make later on when we were looking at submissions, but there are two stages to the approach of the Upper Tribunal, because there was no actual evidence of the actual intention of the parties at the time in relation to whether they were rescinding or varying. No evidence was given as to what that was, and certainly not on both sides, which would have presumably been necessary. What they did was they took the proposition that they would have desired to achieve the tax objective, the EZAs, to be evidence that their common intention must have been simply to vary rather than...
Are you saying that the desirability of the tax efficiency was inferred rather than the subject of any sort of evidence or any provision in the contract?
Do you mean whether they? Well, I think whether they would have desired it was inferred. It was inferred
Yes.
that people taking part in a tax scheme would want the tax scheme to work.
Yeah.
Essentially, so they inferred that the parties to the.
Isn't the foundation of that inference, their finding at 33, that Amtel realised that the enterprise zone would be coming to an end, they took positive steps, etc., to ensure that the ability to claim EZAs on future development of the site would not cease. So that was the overall objective. To go back to Lord Wilberforce's phrase, it's the genesis and purpose of the contract.
Yes, and the dates. I'm sorry, I didn't draw this out in earlier, but of course the dates are very significant because the golden contract was entered into the day before it expired, and indeed the change orders were entered into just a few days, or I can't remember how many days before the shutters came down completely in 2011, and you couldn't claim any more EZAs allowances at all.
I can well see.
So there's no doubt. Yeah.
If you're looking at 2006, and there is a desire to preserve tax breaks for the parties, you construct a contract in such a way that there is the option of what I might call internal variation or performance by different means. In other words, that's why you put in clause 12. So you've got the and indeed you've got the two variations that enable you to hook up options 2 and option 3 over a period of time. And so there are various ways in which it can be performed and maintain the tax breaks. But that seems to me to be an entirely separate question from what happened in 2011 when you then put in the change orders that produces, on your case, option 7. If you're right about clause 12.
I'm not sure. I mean, clearly it was being done in 2006 to create a contract that could be used later.
Yes.
At that stage, I think they thought they were going to do semiconductors because Siemens was there. So it may not have been the intention at that stage to vary the contracts. I don't know. I don't think there's any evidence about that. But anyway, that's what happened. But yes, I mean, the difficulty with, and there's a lot of difficulties with this, but the difficulty with going from the desire to ensure the tax result to the common intention of the parties, which would have to be the developer, the contractor in this case, the common intention of those parties being to do something particular, to create, to have a, to bring about a particular legal result, is that they, first of all, they don't follow from each other. It doesn't necessarily mean because you want the tax scheme to work that you would have any common intention at all about whether the variations or rescissions or whatever. But it also creates enormous difficulty in deciding what contracts mean or what's happened, because the assumption everyone's making is that this works. And does it depend on whether it does work? I mean, the desire is to get the allowances. Supposing what they did doesn't work, they're then stuck with, according to this, the common intention that they had based on a mistaken view of what they should have done, which affects the contracts that they have. None of it really makes sense, frankly, how that can affect the contractual position between the parties. And remember, these positions will continue. These companies are in the same group, but then they've entered into contracts with third parties. They might never not be in the same group later on. The contractual position has to depend on what you can see from the contracts, what they've actually done.
I suppose the high watermark of the argument is that taken against, because you can construe a contract in accordance with what used to be called the factual matrix, so the circumstances surrounding it, you're looking at the time when the contract has been, in inverted commas, varied.
Yes.
So they're making the changes to the contract. Given that the background is this tax break, and you can naturally infer that they would want to structure it in such a way as to continue the tax break, it's part of the factual matrix to say, well, they wouldn't have intended, it would be necessary to the continuation of the tax break that the original contract remains on foot. I think that's probably the way that one can rationalise it.
Yes. And of course, if you're if you're asking a question about construing a particular term in a contract, and there is some difficulty in construing it, one possible aid to construction might be the factual matrix,
Yes.
and that the purpose of the term was to achieve some tax result. But that's not the same as saying simply because you want to achieve the tax result, you must be essentially taken to have done whatever it was necessary to achieve it, which is really what this comes down to in the end.
But actually, I think you sidestep that question, don't you? Because there's no difficulty about interpreting the contract in the sense of what does it mean. Nobody suggests there's any difficulty whatsoever. The question you say is what's the legal consequence of what the parties have agreed. And that doesn't depend on interpreting the contract in the ordinary sense. It depends on something else.
Exactly, yes.
Discussed.
Yes. I think, my Lord, my point was simply that in a context of interpreting a contract, you could take account, potentially, possibly, of the factual matrix in that way, yes.
In other words, to revert to the way you put it in your skeleton argument, the factual matrix is relevant to your stage 1, not for stage 2.
Yeah. Yes. I mean, I find it it's difficult as a matter of analysis to work out whether this is really, in the end, just a matter of statutory interpretation. It's not statutory, contractual interpretation as to what the effect of the contracts is, or whether it's a legal principle that's simply being applied. It doesn't matter in either case. It's carried out in a wholly objective way. Yes, I agree. So we say that the tribunal were wrong in their approach, and that the sort of halfway house suggestion really doesn't make any sense. I mean, if the taxpayer's case is right, then it's really all or nothing. Their intention rules. That's the end of it. If all they're saying is, well, sometimes the court might not believe them, that's a different matter. But I can't really see how that can arise when they're perfectly free to have this intention if they want. You understand what I mean? In parties, why wouldn't they have this intention? Why would a court not believe them? If the intention was that everything will happen in such a way as we'll get the tax relief, nobody's going to disbelieve that, are they? I mean, that's a perfectly understandable intention to have.
Isn't that putting it a bit too high? I mean,
maybe
because the intention is not necessarily going to be fulfilled that you get the tax relief, but that in order to put yourself in the ballpark where you can at least claim the tax relief, it's necessary for the contract to remain on foot.
It's one of the conditions.
I think that's the way of looking at it from the taxpayer's perspective. The taxpayer's perspective is we want to order our affairs in terms of the conditions that we're agreeing now in such a way as to preserve our right to claim the tax relief. Whether or not we ultimately succeed in gaining the tax relief is another matter for the tax authorities ultimately, as to whether we tick all the boxes, but we want to put ourselves in the ballpark to be able to do it.
Yes, no, I accept that, but all the same, that can come to the same thing if all the other conditions are satisfied, and this is the only problem. And presumably this principle would apply to all the conditions. If it was relevant. Yes, I think what the LLPs say is Morris and Barron in all these cases, the approach in them is fine, unless you have an actual agreed intention as to rescission or variation. I understand that's what their case is. That if there is no actual intention of the parties, then you fall back on looking at the contracts and whether they replace each other and go to the root, etc. But where there is an actual intention, you don't do that. Now, one of the problems they have, of course, is there are no cases that have said this, apart from this case, obviously. There's no case that's even hinted at that as being the law. All the cases approach it in exactly the same way.
Well, couldn't they rely on the proposition that it's the converse of the proposition that if there is an express agreement to rescind, that would be enforced. So why, if there is, so that's a common intention to rescind. So why can't a common intention to vary be treated the same way?
Well, because rescission, by rescission I mean ending the contract. Maybe it's a terminology. The parties can end their contract at any time by agreement.
Yeah.
I think rescission is probably best used to refer to cases like this, where it's the effect of what's done that ends the contract.
Yeah.
I think the point I was making is the parties can agree to end the contract.
Yes.
But what they can't agree to is to continue the contract in a situation where they have in fact ended it, or where they have in fact entered into a new contract. Now, can I move then? That's the case law. Now, I'm going to move on to submissions and begin with the construction of Section 298.
Yes.
And all this very interesting argument and debate we've had about variations and is actually irrelevant if I'm right. We're right about the construction of 298 because you have to essentially have the same contract with the same subject matter throughout. And the legislation, it's all in tab A.
Yeah. Page 46 of Authorities A.
Yeah. And then, so can I begin by showing you Section 74 of the Finance Act 1980?
Section?
74 of the Finance Act 1980, which introduced EZAs.
Yes.
So page 13. Now, I'm showing you this at the moment entirely without prejudice to whether it matters at all or whether it's got any relevance, but I'm just showing you it. So the way that this works is Chapter 1 of Part 1 of the Capital Allowances Act shall apply with the modifications specified in Schedule 13 of this Act, as you see, in relation to capital expenditure on the construction of an industrial building or structure. And then the next part's only modifying it for hotels, etc. So we have capital expenditure on the construction of an industrial building. And then it goes on, in any case where the expenditure, which is the expenditure referred to above, is incurred, and the important words are in brackets, or is incurred under a contract entered into at a time when the site of the industrial building or structure or whatever is in an enterprise zone, being a time more than 10 years after the site was first included in the zone. Now what that's saying is that the contract has to be entered into at a time when the site of the industrial building, which is the industrial building that is being constructed and on which expenditure is incurred and claimed, is in an enterprise zone. When it says the site of an industrial building, of course, it means the site of a putative, proposed industrial building. So what that's saying is that the site of the industrial building on which you're claiming relief at the time of the contract has to be in an enterprise zone. It follows from that, we would submit, that the contract you're entering into, and this is at the time of the contract, the contract you're entering into has to be for the expenditure on the industrial building in the enterprise zone for which you're claiming relief. The two are the same. It's not talking about a contract for something else. It's talking about a contract entered into at a time when the site of the industrial building is in an enterprise zone. And that naturally means that the contract is concerning that industrial building. Now, of course, theoretically, you might say, well, it could be a contract for something else, but it happens that the industrial building is in an enterprise zone. But I would submit that's not a natural construction of this provision. This provision is intended, we would say, clearly intended to apply to a case where you have a contract to incur expenditure to build a building on a site, and that's the building on which the expenditure is incurred for which you claim the allowances. So there's no question of varying it to build some different building.
Why not if it's an industrial building and the site is still within the enterprise zone?
Well, because you would have to have decided, well, the original contract could be for, because it has to be the industrial building. So it has to be the site of the industrial building which you're claiming it. It has to be in an enterprise zone at the time of the contract. Why would you ask that question if the contract could be about a different building?
But it isn't about sorry, I mean, I'm being very slow. But suppose that you originally had a contract to construct a factory in an enterprise zone, and at the time when the expenditure was incurred, the site for that intended building is in an enterprise zone. You then change it from a factory to a data centre. Why does that make a difference on the language?
I'm not sure. Can we just let's suppose you've entered into a contract within 10 years.
Yeah.
To build
a factory.
In
an enterprise zone. So the site of the intended building is in an enterprise zone, but you haven't yet built it.
It's an the industrial building. Yeah.
Yes. And then, when the expenditure is incurred, it's a different industrial building, but it's still in the same enterprise zone.
The same site, on the same site.
Yeah.
What you're saying is that the only condition here is it's got to be this. The two
be
things
the
have got to be an
site.
industrial building on the same site.
On the site, yes.
Yes.
Why isn't that right?
Well,
does it even need to be on the same site? I mean, suppose you can foresee that there may well be a highway problem in building this building where you originally envisaged it. So your contract says, well, if the highway comes through, we'll have to move it by 100 metres or 200 metres, whatever it is. Why wouldn't that qualify?
as long as the first condition is at the time of the contract, the industrial building
Similar enterprise
has to be on a site, has to be on the site.
As long as the site is in...
The site has got to be an enterprise zone, yeah, okay. The site's in an enterprise zone when the contract's entered into. And then later, it's varied so that
it's still in the enterprise zone, but in a different place.
As long as it's still the same industrial, because it's got to be the industrial building that's referred to in A. So the industrial building you're talking about at the time of the contract has got to be the same industrial building that you're claiming relief on, because the two are the same thing. So as long as you can say it's the same industrial building, because it talks about construction of an industrial building, and then in the later bit it talks about the site of the industrial building. So I don't think it would be enough that they were both industrial buildings. I think it's got to be the same industrial building.
Well, just to change my lady's example somewhat, you enter into a contract which says you will build either a factory or a data centre. They're both in the contract, but you're only going to do one of them, and you build the data centre. That will qualify on your...
Well, that may be an interesting question. If you enter into that contract, whether that would qualify, possibly or possibly not. That's not this case, obviously.
Right.
Yeah. Then you would say the industrial building is an alternative, two alternative industrial buildings. But they would both be there at the original, in the original contract, in the 10-year period, in this example. Yeah. They'd have been fixed. And that would be rather like the situation here where they chose...
I thought your argument was that until a works option had been selected under the Golden Contract, it just wasn't the kind of contract that came within Section 298. Now, the one I've put to you, where there are two possibilities, you think, well, you say, I'm not asking you what you think, might qualify. So, but it can't be quantitative on the number of options that there are, can it?
And that's not the point I'm making. I'm not making the point that that there are a number of options in the original contract, and that you choose one. Because I don't have to, because that's not what happened here. So I don't have to deal with that situation. They didn't choose one of the options. They built something else completely.
In that case, I've misunderstood your skeleton argument. I thought you were saying that the golden contract could not be a qualifying contract, if that's the right expression, until before such time as one of the options had been selected. No,
I don't think that's no.
that's not your point.
No,
Okay.
no. The point I'm making here is that the requirements of what now is Section 298 are that the contract, when you enter into, if you're looking at a contract situation where the contract is within a 10-year period, the contract has to be to build the building and incur the expenditure that you eventually incur on the building that you eventually build. It's not any contract to build anything that is then varied. That's the point I'm making.
Right.
That all this is saying is, if you enter into a contract within a 10-year period to build an industrial building on an enterprise zone, then you can incur expenditure after a 10-year period on that building. You can incur the expenditure that you've entered into the contract for and claim relief. It's simply a transitional provision. It allows you to extend the time because the contract wouldn't necessarily have completed. That's the point I'm making. That it's the same. That all the section is saying is you've got a contract within a 10-year period for an industrial building on a site in an enterprise zone. You can
build
claim
that building, you can get relief for it.
You can get relief after the 10-year period if you incur expenditure.
Understand.
Because that's what we're saying.
Yeah.
And we say that the way it was expressed at this time is actually makes that pretty clear that was what they were talking about. Because they refer to the incurred under a contract entered into at a time when the site of the industrial building is in an enterprise zone.
Yes.
None of that makes sense unless you're looking at the same industrial building as the one in which you're claiming relief. And we say you get the same from Section 198.
198 or 298?
Sorry, 298.
Yeah.
Section 298. So if you look at 298, the opening words refer to particular expenditure on the construction of a particular building in a particular enterprise zone. 1A refers to 10 years after that particular site was included in the zone. And 10B refers to the particular expenditure being incurred under the contract. That is to say, the obligation to pay the expenditure, we would say, to pay that expenditure derives from the contract entered into in the 10-year period. But I do accept that the way that they've rewritten it doesn't make it as clear as it was under the old provision. But the alternative, I think, is simply to say under 298, as long as there was a contract, which was then successfully varied, a contract within 10 years was successfully varied to be a contract to build an industrial building in an enterprise zone, then you qualify for relief.
Yeah.
Mm.
Those seem to be the two competing constructions as far as I can see. Now, so then we have the question, well, can you look back at the prior legislation? I think this is where my learned friend has an objection to looking at the prior legislation in order to construe Section 298. We sent through a few pieces of materials that I might just look at before we debate this. One was the explanatory notes to the Capital Allowance Act 2001, or some of them at least.
Sorry, where, have we got these in the bundles?
Well, they were sent by email, but I do have hard copies.
Right, I
don't know if Lord Justice Newey, did you receive the?
When did we get these, Mr. Ewart?
Well, they were sent through this morning, I believe.
Don't think they...
My lord, my lady, just to be clear, the first indication we have at this point was, I think, 8:51 this morning, when we received certain materials without explanation. And I gathered from Elaine Friend when we spoke just before 10:30 that there was an intention to run an entirely new point, comparing the wording of section 298 with its predecessors, which is not ventilated in the skeleton arguments or below, and is also contrary to the concession, which is a separate point. So that's where we are.
Right.
Shall I?
Well, I don't have these materials.
Yeah, I will hand them out. There's ones. What they consist of is the explanatory notes to the Capital Allowances Act, which includes section 298, which tells you what it replaced, the provisions it replaced. An annex, which is minor changes to the law made by the Act. So what there is this annex to the Act, which lists all the changes to the law which were actually made by the Act. And I've given you a few pages, but in fact, there's nothing in it about 298. So in a sense, I'm proving a negative. But I mean, I can tell you that it doesn't mention 298 as changing the law. And the other is a case called Nagshini, which is a recent decision of this court, which just sets out conveniently what the principles are in relation to rewrites and looking back.
I think we had it in a case called Quentin Skinner, also not very long ago.
I think that's right. I think you may have had it recently as well. Yes, I think it arose last week as well in a capital allowances context. And I've had this point before. I'm afraid, Lord Justice Newey, I'm sorry that every time we meet, I mention the case that you decided in the Upper Tribunal. But I'm sorry, you're on mute, I think. But anyway, in that case, which was about capital allowances, also had this problem with the rewrite, potentially changing the position of the previous legislation. Anyway, we solved one. Can I then hand up? So you can see the summary in the explanatory notes on page 1. The main purpose of the Capital Allowances Act is to rewrite tax legislation relating to capital allowances so as to make it clearer and easier to use. And then 4, the Act also makes some minor changes to the legislation. These are within the remit given to the tax law rewrite project and the parliamentary process for the bills it produces. And that's where the annex comes in, where it lists the minor changes. And then if we just look to the commentary on section, we said about section 298, which is on page 105 at the bottom. It simply says section 298 is based on parts of sections 1, 6, 10A, 10B, 17A and 21. Sets a time limit on construction expenditure and enterprise zone. Defines 2 terms in the sections. The bit we're looking at actually comes from section 1, remember, of the Capital Allowances Act 1990. As I say, the minor changes, all I can tell you about that is there are no references to minor changes in relation to section 298.
Yeah. Right.
And then finally, the what was said in Nagshini, you can find that at page on paragraph 57 to 59.
Yes, that was the passage from Mr. Justice Sales I was thinking of.
Yes. So there are two principles at play. One is only look at consolidated legislation, but the other is the where there's ambiguity, it's subordinate presumption. It's presumed there was no intention to change the meaning of the provision. So in short, necessary to identify an ambiguity before you can look at the other legislation.
Yes.
So I think the position simply is this: if you think that the position is this provision is clear, one way or another, then you shouldn't look at the past legislation. Makes sense. But if you think that there's two possible constructions, then you can attempt to help you to resolve the ambiguity. I think that's the position.
Would you accept that you can't create the ambiguity by looking at prior legislation?
Yes. So, yeah. You can, though, create ambiguity, I think, to some extent by the consequences of the
Right.
But we would say that there's at least our way of reading it and potentially the other way of reading it, but that is quite extreme, we would suggest.
Yes.
It also means that, I'm not sure how relevant this is, but it also means that you haven't imported into this provision all of these questions about rescission and variation and new contracts, because you don't need to. If that's right, then there's no need to consider the questions about new contracts. What you might have to consider is a different question, which is it still the same industrial building that's being built? Now, the taxpayer, the LLPs say that, no doubt for good reasons, forensic reasons, our case is that there can be no variations at all under the contract. And that's absurd because all building contracts have variations all the time, changes. And of course we accept that the contract could be varied in the sense of a normal building contract, so long as the expenditure is still on the same industrial building. We say there's no reason that EZAs should continue to be available if the parties decide to build a completely different building outside the 10-year period. So of course the normal variations that go on in construction contracts throughout, changing the design a bit and maybe even adding another floor, if Lady Justice Andrew suggests. Certainly taking account of if you find a drain or something that you've got to go around. All these kind of variations are obviously don't stop the contract qualifying under Section 298. So can I then move on to that was statutory construction. Move on to submissions on the clause 12 variation.
Yeah.
And my first point, I think, is one that already has been picked up by Lord Justice Lewison. We have to look at the chronology of the events. At the time of the change order in DC2, the golden contract has already been subject to a notice to proceed under Works Orders 1 and 3 and a change order number 1. And this has resulted in DC1 being built. So it looks on one view as though the contract's already been performed. Whatever way. What we're now dealing with is an instruction under change order 2 to build a second building under the golden contract. And we've already seen that the golden contract is a contract to build one of works options 1 to 6, with certain combinations allowed under the variations. This is the effect of the basic terms of the golden contract. This means that to achieve what the LLPs want, the instructions under the change order must have the effect of varying the contract terms so as to the works and the contract sum, but also as to the nature of the golden contract as a single project contract. And we say that's something which could not be achieved by a variation of the employer's requirements, which is all that can be varied under clause 12. And it seems that this change to the nature of the golden contract is not limited to requiring 2 buildings, because we have DC3, where there was a 3rd building then being built. And one assumes that this could go on ad infinitum until the entire enterprise zone was covered in data centres. Can we then turn briefly to clause 12 of the JCT standard terms? And the LLPs say that this power or right under clause 12 is totally unlimited in its scope. That it can be used to instruct anything, save only for the right of the contractor to withhold consent. But we say there are at least 3 problems with the consent provision in the context of a right to instruct anything. First, it's a weak provision which requires the contractor to demonstrate objectively that delaying or withholding consent was reasonable. If the scope of the power really is unlimited, then it may be very difficult to establish that it was reasonable to withhold consent. Why should it be reasonable? That's what you've agreed. Secondly, if the contractor were to withhold consent, it would be putting itself in danger of being in breach of contract if it was wrong. And thirdly, this is the point I made earlier, this does not apply to an instructed change in the employer's requirements which results in a reduction to the contract sum, which is what the LLPs say is one of the things that's happened in this case. This is because the structure of the clause 12 provisions is not that the change order instruction alters the contract sum, we would say. That's why. It alters the design, etc. of the works. And the financial consequences of that change for the contract sum are dealt with by other mechanisms within clause 12, which we have seen. In particular, the contractor can propose that there will have to be a change in the contract sum due to more works and materials being required, for instance.
But well, I would have thought, would one not, that if, as clause 12 does, it allows the employer to require the omission of work, there might be a reduction in the contract sum, because the contractor is now no longer required to, whatever it is, put in the concrete apron for car parking, or
yes,
the air conditioning equipment, or whatever it is.
Yes. I'm not sure exactly how that would work, because obviously the contractor wouldn't be volunteering a reduction in the contract sum. It didn't seem obvious to me that the provisions would operate to allow the employer to do that.
Right.
But I mean, in any event, it would have to be done under the terms of the adjustment provisions
Yeah.
in clause 12, if it could be done. So, as I've said, the LLP's case is that an instructed amendment to the employer's requirements can have the effect of altering the works and the contract sum. In this particular case, and it did have that effect, that's what they say. The knock-on effect of altering the employer's requirements was then to alter the terms of what the works are in the contract and the contract sum. And we say this argument fails both on factual and legal grounds. On factual grounds, it fails because we don't know what amendment was made to the employer's requirements by the change orders, because we do not have the draft version of the employer's requirements which is referred to in the change orders. Now, the Upper Tribunal dealt with this problem at paragraph 67 to 69 of the decision. Simply records the change orders. 68 records the fact that neither of those documents, the requirements, were produced in evidence, but they did have the later January 2012 ones, which we've seen, and they make the point that these set out requirements for the purposes of a contract between the contractor and its subcontractors.
So just pause a moment at 68. I think it was, they said that they were shown the documents of January 2012 entitled Employers' Requirements Cobalt DC2 Contract Version. I think it was that which sent me off to Bundle D. But you say that isn't that anyway, that's to do with subcontractors.
No, that is it. Sorry, if you that is the document. If you read on, it says these later.
So the subcontractor.
Set out the employer's requirements for the contract between the contractor and its subcontractors.
Yeah.
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 So they didn't have the original document, which was between the employer and the contractor, but they did have the later documents, which were for the purposes of subcontractors. So the LLPs contended that it's been inferred that the requirements in the later document were materially similar to the missing draft employer's requirements. The only evidence in support of that inference, however, was that of Mr. Pulford. While he said that he would expect the requirements set out in the contract versions to be materially the same as those in the drafts, he had little day-to-day involvement in the detail of those documents, and was unable to give direct evidence as to the contents of the draft employer's requirements referred to in Change Order 1, 2 and 3. We do not need to decide what precisely was in the documents, however, as we are prepared to assume that the data centres as built reflected the requirements in them. In any event, HMRC's case is that either the terms of the contract under which the data centres were built, or the data centres were in fact built, were so different from what was required to be built under Works Option 1. It's accordingly unnecessary to consider whether there was any material difference. Now we say that's not correct for a number of reasons. First of all, the amendment to the Golden Contract on which the LLPs rely must have taken place on the date of the change order. It has to. That's the whole case. Not many months later when the building was built. This is because the contract sum has to have been changed on that date, so that it was all paid under the contract before the payment of the capital sum by the LLP on 4th April under the SDA. And it's not an answer, in fact, for them to point to our fallback position, which was, well, whatever the contract said, if you look at what was built, it was different anyway. Because that doesn't answer the fundamental problem. That it's for the taxpayers, the LLPs, to prove that there was a variation on 1st of April 2011 and exactly what that variation was. Because it's they who are saying that they're entitled to the allowances on the basis of that. So it doesn't matter that the revenue are taking a number of points, including look at what was actually built. Anyway, even if we can't find out what you agreed, we know what was built. But the building was actually built, as we've seen, under a much more detailed set of employers' requirements produced many months later. There's absolutely no reason to think that the employers' requirements prior to 2011 were in any way similar. Most crucially, we don't know whether the draft employers' requirements referred in any way to the contract sum. It may be that the pricing for construction had not been done yet. Remember, we're just looking at the variation in relation to construction. That's really the next point. The next problem is that they are only employment requirements for part of the project, the construction to sell and core, which is much the smaller part. How can the employer instruct the contractor to do work which is not specified or costed, i.e. the fit out? Well, they haven't instructed them to do it as on the face of it. So it's clear that this doesn't cover the whole of the contract, which is the relevant interest which is acquired later on by the LLP. All this varies is one part of it, if anything. And the same point can be made against the argument that you must infer a contractual variation. How can the contractor be objectively determined to agree to an unknown and open-ended obligation to fit out costs, fit out the data centre in the future sometime? Now, when you look at the SDA, the terms on which the contractor has agreed that are very clearly set out, and the process by which they will subcontract it, etc. But none of that appears at the earlier stage. Indeed, as I said, they're not even mentioned in the change order. The fit out is not mentioned. So those are factual points. The legal answers, which are equally conclusive. First of all, we adopt. And I'm not going to deal with it now because I can deal with it in reply to what my learned friend says, but we adopt what the Upper Tribunal said at paragraph 76 to 80 of their decision in concluding that this was not a valid variation. We would also repeat the point made by Mr. Cosman in paragraph 83, which they, I think, rejected.
83?
83 of the decision. Yep. The short time scale he was referring to for short time scale that the contractor had in order to price the contract and then suggest what contract sum should be. We would submit that the short time scale provided for in the contract is a pointer against the construction, which leads to there being no limit on the nature or scope of the changes. If that was really intended, then you would expect, that was what the contract provided for, you'd expect the contractor to have more time, more ability to price what could be a very fundamental change to the contract. But the final point, which we would say is conclusive in itself, whatever change the employer's requirement might make, it could not, we would submit as a matter of law, a matter of contract, alter the contract sum. I think I've already pointed out the provisions, but the contract sum is defined in the contract. And it is provided that the contract takes precedence over the employer's requirements and the contract sum analysis, what's called the contract sum analysis, which is in the employer's requirements. So it's just not possible as a matter of construction of the contract for the something in the employer's requirements to override the provision as to the contract sum in the contract.
Well, it will probably be said against you that the contract sum extends to any sum which becomes payable under the terms of the agreement.
But that's not how it's defined. The contract sum is defined as a specific figure.
Is that right? I thought it was defined in a rather more open-ended way. Oh, no, you're right. It's some stated in Appendix 14, etc., being the amount necessary for completing all works required in respect to the relevant works.
It's a fixed amount for each workshop option.
But then it's
But it can be varied under the terms of. I think it also says in the contract. So that the contract sum can only be varied in accordance with express terms of the contract.
Yes, it does.
And there are express terms which allow you to vary the contract sum, which expressly refer to the contract sum, which is some of the ones I've shown you already. So you can vary it in some circumstances, but only in accordance with the express terms of the contract. And one of the ways the contract doesn't provide for you to do it by changing the employer's requirements.
Yeah. Could you just remind me what those express terms are?
Well, I'm sure there are a number, but one of them is in the clause 12 provisions. Remember
The JCT, yeah.
where if there is an instruction given to make some variation, the contractor can say, actually, it's going to cost a bit more. We can change the contract sum. There's a process for doing it, which could lead to arbitration or whatever.
Yeah.
If they disagree about it. But what the employer cannot do, the developer, is simply instruct a different contract sum. And that's pretty obvious, because if you've taken on a contract, you wouldn't want to agree to the other party unilaterally being able to change it. I know that there are some contracts where they can do that, telephone charges and things like that, but in general, that wouldn't be normally allowed. And that if the contractor could do it, then they, as I pointed out, it wouldn't be subject to the consent of if the employer could do it, it wouldn't be subject to the consent of the contractor, because that's limited to changes in design. So it would be a situation where they could literally change it to any figure you liked.
Well,
The contractor could do nothing about it.
yes, I mean, it's taking to an absolute extreme. The employer could say, well, not prepared to pay 150 million for this particular contract, we're only going to pay you 40. But you've still got to do the same amount of work.
And they would do that by, according to my learned friends, by issuing an instruction and an employer's requirement which stated that, which would be unchallengeable as far as I can see, if that was right. Yeah.
Yes.
Now then, can we turn? That was all I was going to say on clause 12. As I indicated, that's a respondent's notice point, so I can come back on that.
Understood.
We're now going to new contract stroke rescission. And we can see the arguments put by the LLP on this issue at paragraph 71 and paragraphs 106 of the tribunal decision.
'71 and 106.
70. So we go to 71 first. Yeah, 71 and 106. But 71, it's the bit at the end, because their first argument, their main argument was a clause 12 argument. So the second argument is, even if the change orders were not given pursuant to clause 12, then the intention of the parties at the time of the change orders was to effect an amendment to the golden contract, not to rescind it. And then 106. You can see at the bottom, 4 lines, Mr. Williamson QC was correct to submit that the parties' common desire to ensure that the EZAs will be available to the purchaser of the building ultimately constructed is strong evidence of a common intention. The change orders would not result in rescission. So those are the arguments which were accepted by the Upper Tribunal. There are many flaws, we would say, in these arguments. First of all, this I think I'm just repeating a point that we've we've discussed already, the general desire that a tax scheme should work does not lead to an ineffective unilateral instruction to vary, which the parties thought was valid at the time, becoming an agreed variation. It is objectively contrary to what the parties did, which was the employers issued an instruction for you to say that there was an agreement on the terms of the instruction between the parties. These are two very different things. One party instructs the other under a term in the contract, all believing it to be valid. It's very different from the parties agreeing something. Whether there is an agreement to vary for the parties to vary is determined objectively on the basis of what the parties do and say to each other. In this case, in fact, the parties did not each in their own minds subjectively intend to agree a variation, or at least there's no evidence that they actually did agree a variation in the sense of a contractual variation. But even if they did, that would not be enough, we would submit.
Would the agreement have come about, well, I mean, whether it's an agreed variation or a rescission, how do you analyse it in contractual terms? You say the employer's requirement is an offer, which is what, accepted by conduct, and the contractor building the building that he was subsequently instructed to build?
Well, this is a point that I think we were making at our skeleton, which my learned friend seemed to object to. If nothing had intervened, so if all we had was the instruction by the employer to build this, and we had the employer's requirements, let's suppose, and the next step had simply been that the contractor went and built the building, then you would have quite an interesting question as to whether there was a contract, or whether, given that they were both under the mistaken apprehension that he had to build it because of the instruction being valid. I'm assuming for this purpose the instruction is invalid, but both parties think it's valid. So if he had gone ahead and built the building, he would clearly have been entitled to be paid for it, one way or another. I mean, either by way of contract, you might have construed it as a contract. Alternatively, you might have said, well, there was no contract, but there's obviously a claim in, quantum merit and just enrichment, whatever, for what he did, because they both acted under a mistake. So that might be an interesting question you might have debated, was what happened then. But that's not what happened in this case. What happened was that 3 days later, they entered into the SDA, which we've seen, which clearly involved contractual agreements to build the building. So there's no question of looking at what they did and it having any effect on this. It simply is not what happened. But I wouldn't necessarily accept that even if nothing had intervened, and they'd build the building on the mistaken apprehension that they were obliged to, that there would have been a contract because of that. So the second point is that the terms of this agreement are unknown. The agreement that they had. What we do know is that there were no terms at all at that stage in relation to the fit-out. And it doesn't insist that the data centre was in fact built to shell and core. All of the agreements necessary to build it are contained, as I said, in the SDA. The change order, in fact, whatever its effect or meaning, became practically irrelevant 3 days later, 3 days after it was given, when the parties entered the SDA. And thirdly, whether an agreement varies a contract or is a separate new contract is a matter which has to be determined objectively, looking at the terms of that agreement, or comparing the terms of both agreements. It's a matter of legal analysis and not determined by the subjective desires of the parties. And we say labelling those subjective desires as intentions doesn't help. In contract law, the intention of the parties is determined objectively on the basis of what they say and do. And fourthly, even, which we deny, subjective desires or intentions were relevant, there was no evidence or findings by the UT that the controlling minds of the two companies had any actual intention at all in circumstances in which the Clause 12 instruction was ineffective. Because it didn't arise. Nobody thought it was ineffective. The best that could be said is that if they had been asked, suppose the Clause 12 instruction is ineffective, would you want to do whatever was necessary and possible to allow the LLPs to claim EZAs? No doubt they would have said they would. At that level of generality, but that didn't happen.
I'm just being a bit slow here. So, first argument that the LLPs put forward is it's all fine under Clause 12. If they're right, you lose. So we're approaching this
Subject to the construction point.
on Section 298.
Yeah.
Yes.
Yeah, you will lose it.
So let's assume they're wrong for the purposes of the submissions you're now making. So the employer's the change order is not given under Clause 12.
It wasn't a valid exercise of Clause 12. Yeah.
The question we're now discussing is, has there been a variation of the golden contract, or has the golden contract been terminated?
Has there been yes, or has there been a variation so it continues, or is there a new contract?
Yes.
With possible termination? Yeah.
For there to have been a variation, there would have to be agreement, would there not, by both parties to the varied contract.
Absolutely.
We have the evidence of the employer's, with a change order, which is an instruction from the employer, but unless and until the contractor agrees to it, how can it vary the contract?
That's my point. And you can't spell it out.
So wait a minute. So you say that there is nothing. I mean, maybe I've just been looking at the wrong target here. There is nothing which indicates the contractor's acceptance of the employer's requirement. Is that what you're saying?
Well, in fact, there isn't actually.
So all you've got is the SDA.
Yes.
So you're not then. I mean, I thought we were comparing the golden contract as original with the golden contract as varied by the change order, but I don't think you are saying that. I think you're saying what we are comparing is the golden contract and the SDA.
Well, I don't think
because there is no intermediate contract.
We don't need to, yes, but I don't think there's any suggestion that the SDA varied the golden contract. I mean, there's no doubt the SDA is a separate contract, a different part. It's got other parties to it. It's a completely different contract.
Yeah. Well, then
so there's no question about that. The only question is, was there a contractual, when we get to this point, both parties believed that there had been an instruction given validly under Clause 12 at this stage. So that's what they believed. The question then is, if it wasn't valid, can you then spell out of the circumstances, as they were, a contract to vary, and an agreement by the parties to vary the contract? And I'm saying that would be inconsistent. First, there's a number of points. I mean, even if you can, I would say it's not a variation, it's a new contract. But my first point is, it's totally inconsistent with the parties' beliefs at the time.
So I'm just trying to think this one through.
They were varying it.
The employer's requirement is not itself a variation, it is a requirement. So the change order does not affect a variation. It could, in point of legal theory, be the precursor to an agreed variation, but that would require the contractor's consent.
Yes, although I think consent might not be the same as agreement.
Agreement, all right, agreement.
Agreement, yes.
Agreement. There is no evidence, you say, of the contractor actually having agreed to this change order. Therefore, the change order did not vary the golden contract. Therefore, the golden contract remained in being unvaried, but the expenditure was not incurred under the golden contract as unvaried. It was only incurred under the SDA. Is that where we get to?
It would have to, yes, because the golden contract provided for different consideration.
So this whole idea of rescission variation doesn't matter on this analysis, because the golden contract, you say, never was varied. never was varied to include DC2 or DC3. They just weren't anything to do with the original golden contract.
And the reason that the taxpayers, the LLPs, say it was varied is because of the intention of the parties.
Yeah.
And I say that doesn't lead to a contractual variation of a contract.
But also it's inconsistent with their actual intention, because if they were all labouring under the misapprehension that Clause 12 worked...
Exactly, yeah.
Your point is, they all thought that they were performing the original contract by making a direction under Clause 12. If they were wrong about that, if they were mistaken about that, you cannot then reclothe that by characterising it as an intention to vary the contract, because they all believed at the time that they weren't varying it; they were performing it as currently allowed. And so you can't spell out an intention to replace that contract, let alone to vary it in any material particular, when both parties are labouring under the misapprehension that they're entitled to do what they're doing under the terms of the contract itself.
Well, the employer is entitled to it. The contractor is obliged to.
Yes.
Yeah. Yes.
Well, might you say that the contractor did agree by accepting the money that was paid?
It certainly didn't send it back. but well, no, because it believed at that time that it was obliged to. I mean, remember, they all think that this was a valid exercise of the Clause 12 power. So they believed that had varied the contract validly on the terms of whatever it was in the change order and the employer's requirements, which presumably at that time they did have, so they knew what they were, one assumes. So it thought that. It wasn't being offered by the employer as contractual consideration, in the sense of consideration for an agreed variation. It was being offered as payment under the change order provision. But in it, that also doesn't really make any, as I said before, it doesn't make any sense, because there must be more to this that we don't see, because the change order only required them to bill to Shell and Core, and the 54 million was a payment for the entire contract, including the fit out. So the two things just don't really work. It doesn't make sense. It doesn't also make sense that the employer would make an agreement on the terms, literally on the terms of the change order, because then they would have to pay the 54 million and only get Shell and Core billed on the face of it. So as I say, there must be other terms that we don't know about. But anyway, so that we say that's a fundamental problem. But in any event, any agreement on the terms of the change order, if there was one, would have resulted in a new contract. And there are a number of reasons for this. First, I have to remember that a building project had already been carried through by way of variation of the golden contract. And so this is a point I made earlier, that the variation affected by this would have to have varied the contract in a fundamental way, so that more than one works could be built under it.
Well, it was varied to allow that.
Well, exactly, but that we would say that's a fundamental variation of the very root of going to the root of the contract, which is that it's a contract for one works option, or a combination of two works options.
So you'd say by the first or second variation agreements, that had already brought into being a new contract.
There was by the first or second, you mean the DC1?
No, the ones at the back of our bundle.
Oh no, that didn't, because I think all that was providing for was a combination,
yes,
a single exercise, but a combination of works options.
Oh, I see.
Yeah.
Oh, I see.
So they weren't limited to one, but it was a limited number of.
So it started life with any one of 6, And then as a result of the variations, you could combine 2 and 3 and have those two, but only those two. You couldn't have 1 and 4 or 3 and 4. You could have 2 and 3.
Yeah.
And that's all still under the umbrella of the original contract.
Yes.
What
Or you could have 1 and 3
7.
later. Yes, exactly.
What you get is 7 because you can't do 1 anymore because there's a building on 1 and that option's already been exercised.
Yes. So this required a fundamental, as I say, variation, but it also had to vary it to provide for a completely different building than that was provided for under the Golden Contract. It had to vary it. It varied it to provide for a completely different contract sum, about half the contract sum, under Works Option 1, which was the one that they selected. And it would have to, the variation provide for the new building to be built on a site other than that referred to in Works Option 1, which is what, again, as I say, this is what they selected. So the Golden Contract was to build whatever it's built under Works Option 1 on the site. Sorry, I've lost my piece of paper on where DC1 is. But that's not what the variation provided for. It provided to build a different building on a different site. And we would say singly, but certainly together, these all are mean that the variation is entirely inconsistent with the original contract. Now, so I think the first thing I have
whether that is so, would you agree, is an evaluative exercise?
I think, well, to some extent. I mean, I think there may be some analysis involved in it as to whether contracts are inconsistent, which requires you to analyse the terms.
But then you've got to form a view as to whether they are inconsistent.
And sufficiently inconsistent. So that would be evaluated, yes. Yeah.
If we were to take the view that is in effect what the UT did at 108, you would be in some difficulty, would you, appealing on a question of law?
Not because we say that they started off.
You say they started off on the wrong foot.
On the wrong footing.
That I understand.
Yeah. So they didn't answer they didn't think they were answering the question that they should have been answering, we would say. And that's why they came to the conclusion. Well, if you look at 109, none of those differences, whether individually or together, was inconsistent with the parties having a common intention.
Yeah.
So they started off from asking, did they have a common intention? Then they asked, were any of these inconsistent with them having this common intention? No, that's it. Whereas what they should have been asking is determining the common intention
from what the parties agree.
Yeah, that's right.
Yeah.
So unless there are any other questions, I think that's all our submissions on the appeal.
Right. Very good. We're ahead of time.
My Lords, if I can begin by making the same apology to Lord Justice Newey that my own friend made. My Lords, our submissions on the appeal are summarised in the following 5 propositions. If I can just give you the propositions and then I'll develop them in turn. First, the Upper Tribunal correctly found that the distinction between rescission/new contract on the one hand and variation on the other depends as a matter of law upon the intention of the parties objectively understood. 2, the Tribunal rightly found on the facts that the parties to the Golden Contract intended objectively to vary the contract. They did not intend to rescind it or enter into a new contract. 3, the law on the, quotes, 2-stage test, those quotes, is of no relevance to the question before the court. 4, so far as the section is concerned, the expenditure incurred under the Golden Contract in respect of DC2 and DC3 answers the statutory question because 1, there is expenditure on the construction of the building, and 2, the expenditure was incurred under a contract entered into within 10 years of the site first being included in the zone and within the 20-year long stop, and 5, further and or in any event DC2 and DC3 were constructed pursuant to changes instructed under clause 12, and that's the cross notice. So my lords and my lady, beginning with the law on rescission and variation, in my submission, and I realise that I'm in danger of teaching grandmothers, etc. But it is useful just to start with some black letter law. And if we could look at Chitty, at Authorities Bundle C, tab 40. At page 943.
Yeah.
Para 25034, a statement of the obvious that the parties to a contract may effect a variation of the contract by modifying or altering its terms by mutual agreement, and examples are given. One needs, in my submission, just to stand back for a moment and remind ourselves that the parties are masters of their contractual fate, subject to matters such as unlawful agreements. They can agree whatever they like, whether that agreement is the initial contract or a variation of a contract. And in general terms, there is in my submission no principle that the parties are in some way inhibited as to how far they can go in varying their contract, subject only to the line of cases beginning with Morris and Barron, which is referred to on the next page at 25036, where it will be seen in the middle of the paragraph there is the quotation from Lord Haldane, which we've been to, and then the learned editors say this: at the end of the day, the question whether there's been a rescission or a variation depends upon the intention of the parties as evidenced by the terms of the subsequent agreements and the surrounding circumstances. And then this: thus, if it was their intention to replace the initial contract, the subsequent agreement may amount to a rescission, even in cases where the subsequent agreement is not fundamentally inconsistent. So, in my submission, essentially this is a question of fact. What was the intention of the parties, objectively determined? And just by way of slight digression, it is worth noting that in construction contracts, it is very common to have agreement for additional or varied works, even outside the mechanism of the contract, here clause 12. So for example, works may have gone amiss for one reason or another, and the parties may say, well, rather than going through the contractual procedures for claiming additional time, additional money, and so on, we'll enter into a deed of variation whereby, for a lump sum money, the contractor gives up all of his contractual claims and gets on with the work.
Yeah.
Equally, it may be that a contractor is in delay for whatever reason, and the employer has commercial imperatives to complete by a particular date instructs acceleration, that's to say applying additional resources, which isn't required under which isn't he's not entitled to under the contract, but the parties agree that will be the terms. And the example I think the lady gave earlier, which is very topical, which may be that you have a contract which requires a lot of aluminium, the price has gone up by 200%, there is no provision to uprate rates for inflation in the contract, and the parties commercially agree that there will be an additional payment in exchange for the contractor performing the aluminium-based work. So, so those are all common situations.
But where do we find the agreement in this case?
My Lord, the agreement, I was listening with interest to the debate your Lordship was having with a learned friend a moment ago. In my submission, the agreement is, if we can't rely on clause 12, it is to be derived from the instructions coupled with the payment of the 54 million and the 42 million, or whatever it is, coupled with the performance of the works. So, just
now the UT, I don't think made that finding.
Well,
I don't know quite where the UT got its agreement from. They don't really explain.
Well, they found those facts, and I think one can infer.
But they don't say what amounted to the agreement.
Well, as far as I remember. Yes, in fairness to the UT. I'll be corrected if I'm wrong, but my friend, I don't think it was submitted on behalf of HMRC that there was not a contractual agreement in 2011 for the construction of DC2 and DC3. That point simply never arose. And I don't think it was put either by way of submission or cross-examination or whatever. So, just coming back to the law then, in my submission, it would be a strange result if the law required that parties who have a contract, but now both have agreed that they want, for example, a different price or a different building or a different site, must enter into a new contract and rescind their existing contract if they are both content to proceed under their existing contract as varied. Why should they not be able to do so? And in my submission, the tribunal, Upper Tribunal, correctly summarised the law, and I think the court's been taken to the relevant passages. So can we go then to Morris and Barron? So that's Authorities Bundle A, tab 7. The court has been taken through this in some detail. I'm not going to repeat the summary of the facts for known friends given, but I just wanted to highlight some of the passages in the judgments. But just before we do that, as I think Malone Friend has explained, Morris and Barron and British Benningtons are both dealing with esoteric difficulties which are created by the legislation and by particular legislation. When we get to Samuel and Wadlow, with respect to Lord Justice Toulson, as he then was, in my submission it's absolutely right to say that in most cases it's not going to be of any commercial interest to the parties whether they are varying contract A or entering into contract B. What most parties will simply do, if they have contract A, and they both wish to change it, is to enter into a variation of it, so contract A remains on foot in varied terms. That is the natural commercial thing to do. So one does need to contextualise, in my submission, the intellectual gymnastics in which their lordships engaged in that sense. But just picking up some of the passages, then, if we could look at Lord Finlay at page 82. And forgive me if we've looked at some of these passages before, but just so that to get the full picture. Lord Finlay says at the bottom of page 82, he quotes a decision of Lord Denman's, to this effect: "It seems to us that we are mainly called on to decide a question of fact, namely, what was the intention, what namely is the intention of the parties, did they intend to substitute a new contract for the old one, the same in all other respects except those of the day of delivery, etc., etc." Then Lord Finlay discusses the facts of the case before him, and then he says this at the bottom of 83: "The evidence in the present case points to the conclusion that the parties intended not merely to vary the original contract, but to set it aside and substitute another for it, giving a mere option to take delivery of the parcel undelivered."
It's difficult, isn't it, to suppose that the parties intended that they should be left with no enforceable contract at all.
Is your lordship talking about our case or this?
No, this case.
Yes, indeed, yes.
Yet that's what the House of Lords found. So it's not, I mean, it depends what you mean by intention. It's very difficult to suppose that the parties intended the result which the House of Lords said they had brought about.
Well, the House of Lords was with great respect, was fitting the law to produce a fair and reasonable outcome, bearing in mind the Section 4 point. But nonetheless, this the principle in my submission is clear. Then, if we could turn to Lord Haldane.
Yeah, well, he's pretty clear on the point. You
He's
can
pretty
make
clear.
whatever changes you like, no matter how sweeping.
Yes. So that's page 89.
Yep.
He speaks with but one voice amongst five.
Well, my lady, we'll come to see how that voice resounds down the ages in a moment. But just if we just stay with Lord Haldane at page 92, it is striking what he actually concludes. He concludes that the April agreement amounted to a complete rescission and abandonment of the old agreement and the substitution of a completely new and self-contained agreement. So it's a fairly extreme finding. Then Lord Dunedin at page 97. At the bottom of the page, he has discussed various interpretations of Noble and Ward, and he says this just below the hole punch. The criterion does not lie in the question of whether the later contract is itself a contract which needs to be in writing. The criterion is in the question whether what is intended to be affected, by the second contract is rescission or variation. And then at 99, I think it may have been to this, my lords, it seems to me impossible to come to any conclusion on this, but that the parties agreed that the old contract should be abrogated. I use the words abrogate because I think it is a better word than rescind when you deal with a contract. Then Lord Atkinson at page 104. The bottom of the page, it is, I think, impossible to arrive at any rational conclusion as to the meaning, aim and effect of this new arrangement, other than this, that it was the clear intention of both parties to put aside in their future dealings the original agreement and to treat it thenceforth as abandoned or non-existent. And then finally, Lord Parmore at page 107. His opening remark at the beginning of his speech, "My Lords, in my opinion, the determining factor on which the appeal depends is the intention of the parties when the arrangement was made. This question is one of fact and depends on the conclusions to be drawn from the acts and conduct of the parties." And then, having reviewed the facts, he says in the middle of page 109, at the second hole punch, "I've therefore come to the conclusion that it was the intention of the parties at the time when they made the April contract to rescind and put an end to the earlier contract." So, in answer to Milady's question, in my submission is Lord Haldane in Morris and Barron is not a voice in the wilderness. It is his speech is consistent with what all of their other lordships say, one, and two, in my submission, insofar as one is considering inconsistency, that is simply an ingredient, it's one factor in assessing what the intention of the parties was, but it is the intention of the parties which governs.
Yeah. If you go back to Lord Haldane at page 92 of our bundle, in the page, the second paragraph on the page starting, "My Lords, I've come to the conclusion." He says that the letter sets out the result of the conversation. That's the only admissible evidence of the terms, and then he proceeds to analyse those terms. So, I mean, he's looking at what the parties did. Same with Lord Parmore. The bit that you referred us to, bottom of 107, top of 108, crucial factor in determining conclusions from the acts and conduct of the parties of the parole arrangement, that is to say, what's in the letter. So they're looking at intention in the sense of what you get out of the document.
Absolutely.
On the facts of that case.
Yes, I agree. Yeah, but my Lord, to be absolutely clear, we're not saying that the law of contracts should be subverted such that we are seeking to have windows on men's souls, as it were. Subjective intention is not relevant. It is the common intention to be drawn objectively from what they've done and what they've said. There's no doubt about that. But it is common intention which governs. And my Lord, just going back to a point I was making a moment ago, if one puts to one side for a moment the context, the taxation context in which our case is operating, or the Section 4 context applicable here, clearly, if parties intend to keep a contract but in varied form, then in almost all circumstances the court will give effect to that intention. If they intend to enter into a new contract, the court will give effect to that intention. And the intention, as I say, obviously, is to be taken objectively. But it would be a very surprising conclusion in my submission if the court concluded, well, the parties objectively intended to vary their contract, but we, the court, think that there are substantial differences in the new arrangements, so they're not to have that which they intended, they are to have foisted on them a new contract. That can't, in my submission, be the law.
Well, you don't start with the intention, you start with the contract. And you try to discern the intention from the contract.
Yes.
Once you've discerned the intention, you give effect to it.
Well, you give effect, my lady, to the intention to be drawn, as it says here, from the acts, words and conduct of the parties. And in my submission, British and Bennington's does does not take the matter very much further, save for the passage which I think Milady drew attention during Malone and Friends submissions at page 133 of the bundle, tab 8. Where Lord Sumner is quoting from Morris and Barron, which he summarised as being the question is whether the common intention of the parties was to abrogate, rescind, supersede or extinguish the old contracts by a substitution of a completely new and self-contained or self-subsisting agreement containing as an entirety the old terms modified.
But then look at the test he actually applied, page 134. Change does not go to the very root of the original contracts, nor is it inconsistent with them. It merely varied the written contract by parole. So the test that he actually applies is, does the change go to the very root? Is it inconsistent?
Well, so your Lordship's ahead of me. Could you just
Page 134, middle paragraph, under these circumstances.
Yes, yeah. Well, my Lord, I don't think that really cuts across the submission that I was just making, which is that it's the common intention of the parties, and the court is entitled to look at all the circumstances.
Yeah.
Well, it's just a longhand way of saying that if the parties have agreed to deliver the cargo somewhere else, it doesn't actually alter the fundamental substance of the contract, which is the contract for the sale and delivery of goods, in circumstances where they still want to perform that contract. So it's just change of venue for delivery.
Yeah.
It doesn't change the nature of the contract. It doesn't really change the terms of the contract in terms of payment. It just means that, not substantially anyway, I think there's a slight premium on payment.
So I was going then to take you, if I may, to three further authorities in which Morris and Barron has been followed and applied. First of all, tab 11 in the same bundle. I think we saw an extract from this in Samuel. This is UGT and shoe care, and this raises somewhat abstruse questions under the money lending law of Jamaica, which I don't think we need to wrestle with, but just to see how Lord Devlin deals with it at page 198. So, Lord Devlin explains the historical background of the notion of unenforceability of the statute of frauds, the Moneylenders Act, and so on. And then over the page, he says this: the disadvantage of what Lord Sumner had described in British and Bennington's as the logical view is that a minor variation may destroy the effect of the whole of the transaction between the parties. The alternative view is based on the intention of the parties. They cannot have that which presumably they wanted, that is the old agreement as amended. So the court has to make up its mind which comes nearer to their intention, to leave them with an unamended agreement or without any agreement at all. And then he summarises the position as this: if the new agreement reveals an intention to rescind the old goes, and if it doesn't, the old remains in force. Then, if we could then go to Authorities Bundle B, tab 25. This is an authority we haven't referred to.
So Lord Devlin is contemplating the case in which you can't give effect to the party's intentions.
Well,
You've got to choose which comes closest. So you can't give them what they actually wanted,
No.
So you ask, well, what's the next best thing?
Yes. Yes. So could we go in bundle, authorities bundle B to tab 25?
Yeah.
So another Privy Council case. Again, I don't think I need to detain you with the facts, but if we could go to page 482, which is the judgment of Lord Scott. Having set out the facts, he says at para 19, their lordships must now return to the only real issue in the case: did the February 81 agreement rescind and replace the 1980 agreement? The general principle is expressed in Chitty, and I haven't done a complete textual comparison, but that's very similar to the passage I showed you at the outset. He then quotes from Morrison Barron, and then says this at 21: the question whether in signing the later agreement they intended to discharge the earlier agreement is a question of fact to be decided by inference from the surrounding circumstances and the contents of the two agreements. And then finally, if we could look at
Just a moment before we leave this case.
Yeah.
Can we just go on to 21, to further down 21? Lord Scott says that the Court of Appeal said never any intention to rescind, etc., etc. And then Justice of Appeal Lucky says he agrees with the judge's findings, explain why. And he says the only variation effected by the second agreement is a new date of completion, as to which there was mutual agreement. The change did not go to the root of the first agreement. Evidence discloses the second agreement was not inconsistent with the first agreement. And then Lord Scott says they can find no fault with those principles. So that's another case of inconsistency, going to the root of the contract, being applied to decide whether what we can call a mutual change, use a neutral expression, is or isn't a variation.
well, my lord, yes and no, because if you just go back to page 483,
Yeah.
at the earlier part of paragraph 21, he quotes the trial judge's finding in the three lines he's quoted there, and he then says this is not quite an explicit finding on the question of the party's intention, but is tantamount.
Yes.
So that is those are the facts upon which Lord Scott is focusing.
Well, yes, but it's consistent because the finding by the trial judge is that the concern about the receipt in no way detracts from the efficacy or merits of the early agreement. Well, that's just another way of saying it doesn't go to the root of the contract and it's not yet inconsistent with it.
Well, the finding which Lord Scott is commending from the Court of Appeal, I think it is Justice Lucky agreed with the judge's finding of facts that the parties had no intention to rescind the agreement.
For the reasons that he then goes on to give.
Yeah.
Yes, I mean that's why he agrees with the finding of fact. The reason he agrees with the finding of fact is that the change didn't go to the root of the contract.
Well, my lord, I think with respect, what Lord Scott is agreeing with is that that the test is intention.
Yeah.
And one looks at all the relevant circumstances.
Yes.
And then finally, and I will detain you for a little bit longer on this case, if I may. There's a relatively recent decision of the Supreme Court, which I think is very much, which I submit is very much on point. Bundle C tab 35.
Yes.
Could I be so bold as to invite the court to read to itself the head note at 735,
Yeah.
which summarises the
This
facts.
was about whether a CFA covered an appeal.
Yes. Yeah.
Do you want us to read the whole of the head note?
I was
Just the
hoping,
facts.
I was hoping your lordships would read the whole of the head note if that's acceptable. You probably don't need to read holding 3 on page 736.
Yeah.
So we've got a CFA which predates LASPO. We've got LASPO, which is outlawing success fees, and then there are variations entered into post LASPO to the pre LASPO CFA. And the argument, the judgment is given by Lord Sumption, but speaking on behalf of his fellow Supreme Court justices, and he deals with this point that begins at page 739.
Yeah.
So paragraphs 9 to 11 summarise the factual history and the legislative change which has occurred. And then at paragraph 12 on 740, he says this: Paragon's case is that in relation to the proceedings, the variations were new agreements entered into after April 2013 for the provision of litigation services. They were not therefore covered by the transitional proceedings. That's a bad point, he says. And then he says this: it follows that unless the effect of the deeds was to discharge the original CFA and replace it with new agreements made at the dates of the deed, the success fee may properly be included in the cost order. Whether a variation amends the principal agreement or discharges and replaces it depends on the intention of the parties to establish a discharge and replacement. And he then quotes the famous passage from Lord Haldane, which we've looked at possibly more than once, then he finds on the facts that the CFA was still in force at the time of the deeds of variations. Both deeds were expressly agreed to be a variation of the CFA, leaving all of its terms unchanged, except for the addition to the coverage of a further stage. While the description given to the transaction by the parties would not necessarily be conclusive, if the alleged variation substituted a different subject matter, this cannot be said of either of the deeds of variations. So, in my submission, that is a strong and relevant authority on the point with which we're dealing. Because in this case, the variation rescission difference really did make a difference. Because if Lord Sumption had taken a different view,
Yeah.
then the subsequent agreements would have been of no effect. And Lord Sumption A says in terms that this depends on the intention of the parties, and B relies for that proposition upon the passage in Lord Haldane's judgment in Morris and Barron. And that was why I said to my lady a little while ago that Lord Haldane's speech does still resound down the generations.
Is that point finished now?
Ish.
Ish.
Yes.
All right. Well, we'll stop there. Thank you very much. 10:30 tomorrow.